Are you ready, kids?
Aye, aye, Captain!
I can't hear you!
Aye, aye, Captain!
Oh! Who lives in a pineapple under the sea?
SpongeBob SquarePants!
Absorbent and yellow and porous is he.
SpongeBob SquarePants!
If nautical nonsense be something you wish,
SpongeBob SquarePants!
then drop on the deck and flop like a fish!
SpongeBob SquarePants!
Ready? SpongeBob SquarePants! SpongeBob SquarePants! SpongeBob SquarePants! SpongeBob SquarePants!
Welcome aboard! This video presentation will definitely not be as exciting as listening to SpongeBob theme songs. It will explain the whole process of international shipping, which is confusing, messy, and truly boring. So maritime transportation is the backbone of global trade and the global economy. It is one of the main modes of transporting food, technology, medicines, and all of the goods one can imagine. Sellers enter into shipping contracts with the shipper, who often is the owner of the vessel, to transport the goods to the buyer. One thing to point out is that every international shipping contract is different, and it can be really complex. There are more than 300 different surcharges that can be applied by shippers worldwide.
Where is it? It's right here, Captain. I never thought I'd see it with my own eye.
Critical documents to a shipping contract! The critical documents to an international shipping contract can vary. Basically, confirmation notes and standard form contracts will list a number of documents to be tendered to the buyer and will often spell out some of the characteristics these documents should have to be acceptable. Generally, there are two essential documents to every shipment sale: the commercial invoice and the bill of lading. Depending on the type of shipping contract, insurance policy and letter of credit are also very important documents in the complex process. The commercial invoice is a request for payment, kind of like a bill, sent by the manufacturer or seller of goods to the buyer or exporter. It includes most of the details of the entire export transaction from start to finish. As regards the bill of lading, every sea transfer in the world starts with an issuing of a bill of lading document that acknowledges the receipt of the cargo. It is issued by the agent of a carrier to a shipper, signed by the captain, agent, or owner of a vessel, furnishing written evidence regarding receipt of the goods, the conditions on which transportation is made, and the engagement to deliver goods at the prescribed port of destination to the lawful holder of the bill of lading. So how exactly does a bill of lading work? Well, first of all, the carrier creates a bill of lading and sends it to the exporter. After receiving payment for the goods from the importer, the exporter sends the bill of lading to the consignee. Then, the importer takes over the goods at the final destination by presenting the bill of lading to the release agent. One other important document on international shipping contract is insurance policy. If the goods are sold on cost, insurance, and freight terms, the seller will also need to tender an insurance policy covering marine risks and any additional risks agreed in the sale contract. One other important document is a letter of credit, which is a document issued by a bank per instructions of a buyer of goods, authorizing the seller to draw a specified sum of money under specified terms, usually the receipt by the bank of certain documents within a given time. Where a letter of credit has been agreed as the method of payment for the cargo, the credit itself will ask for a list of documents to be tendered. International shipping contracts can be categorized in three forms or layers of contract. In the current commercial practice, sale contracts are concluded by exchange of short emails, faxes, or confirmation notes focusing mainly on the description of the goods to be sold and the main delivery and payment terms. This constitutes the first layer of contract. These notes in turn provide for express incorporation by reference of one of the Incoterms, which will be explained shortly after, and or longer and considerably more detailed standard forms such as the ones provided by trade associations like GAFTA or FOSFA. This constitutes the second layer. The third layer consists of further incorporation of terms from other standard forms of in-house models, rules, and/or procedures, which will come to form a third layer of contractual clauses. Because of the three layers, identifying the exact terms agreed upon by the parties may not be straightforward. However, the court or tribunal with the proper established jurisdiction will look at the parties' intention and check whether there is any clear hierarchy clause of the layers. Where no hierarchy clause is drawn up, the principle is that where there is clear conflict between two clauses, specially negotiated terms would prevail over standard terms and conditions of sale. A good understanding of Incoterms is essential to a successful international transaction. Incoterms developed by International Chamber of Commerce are widely used in international and domestic contracts for the sale of goods. These terms make sure that both the seller and the buyer know who is responsible for the transportation costs, where goods should be picked up and transported to, and who is responsible for the goods at each step during the transportation. These terms have in itself no binding force, so if both parties agree to use the Incoterms, they have to incorporate the right term in their sales contract and detailed confirmation note. Cost, insurance, and freight term and free on board term are international shipping agreements used in the transportation of goods between a buyer and the seller. They are among the most common of the 12 Incoterms. For both terms, the seller loads cargo on vessel and pays for shipping delivery costs.
Oh, Mr. Krabs, I am so confused.
The cost, insurance, and freight contract is the most comprehensive and widely used international export trade contract, and covers the contract of sale between seller and buyer, contract of carriage, and the contract of marine insurance. It is considered a more expensive option when buying goods. In free on-board contract, the seller is free of any obligation to pay insurance and freight, but undertakes to place the export goods aboard the nominated vessel and port of shipment. Free on-board contract relieves the seller of responsibility once the goods are shipped. The critical transactions are obviously covered by the bill of lading, which performs three main functions. Firstly, it provides evidence of a contract of carriage with the carrier entitled to sue such carrier on its terms in case of breach. Secondly, it gives constructive possession of the goods and the right to control and dispose of them. And thirdly, it functions as a receipt for the goods shipped. In this part of the video, I will focus on some of the most common variations in terms that sellers and buyers need to consider under the international trade terms, so that to ensure certainty about the point at which risk is transferred. They may be further divided into three main groups depending on the mode and place of delivery of the consignment sold. Again, these terms are Incoterms. Firstly, we have E-terms, or ex-work contracts. These terms regulate the delivery of the goods when it is made at the seller's premises. D-terms, or also known as destination, arrival, or delivered contracts, regulate the delivery of the goods when it is made at the buyer's premises. Shipment terms are terms which regulate the delivery of the goods when it is made generally on board the vessel at the loading port. The variations in contract also depend on the type of bill of lading which is issued. In certain circumstances, the bill of lading will contain the terms of a contract of carriage. There are typically three types of bills of lading. Firstly, straight bill of lading, in which the carrier received the payment in advance. Secondly, order bill of lading, in which the goods will be transported before payment received by the carrier. And thirdly, endorsed bill of lading, in which the shipper transfers the title of the goods upon the delivery. There are several ways in which the contract deals with risks. First of all, the parties can agree upon the allocation of transit risks in contract with ad hoc clauses. So, for example, when the risk shall pass from one party to another, this depends on the Incoterms in the contract. Secondly, cargo claims are mostly brought by cargo interests, such as the shipper of the goods, the receiver, charter of the vessel, etc., against carriers when the cargo in which they have an interest is not delivered, is delivered short, or is delivered damaged. There is a 5-tier test that has to be taken in order to initiate a cargo claim. The first question is whether the claimant has a title to sue the defendant. This question conceals two different but related issues: the claimant's title to sue and the identity of the responsible carrier. The second question is whether the Hague-Visby rules apply. The answers to the questions which will follow will depend on whether the claim is subject to the Hague-Visby rules. Without an express choice of law, it will apply in situations where the bill of lading is issued in a Hague-Visby contracting state, the carriage starts from such a state, or the bill of lading expressly incorporates the legislation of a state giving effect to the rules. The third question is whether the claimant can prove its loss. The claimant definitely needs to prove its loss. This question focuses on the function of the bill of lading as a receipt. The evidential force of the bill of lading is of great significance at this stage of claim. The fourth question is whether the loss caused was by a breach of duty. The claimant needs to prove that that loss has been caused by the carrier's breach of duty owed to the claimant in law, whether in contract, in bailment, or in tort. And the fifth and final question is whether the carrier can exclude or limit its liability. The carrier could extinguish the claim either by arguing that the claim has been time-barred or by pleading one of the exceptions to liability allowed by the Hague-Visby rules. The third way in which the contract deals with risks is by a letter of credit. A letter of credit, as briefly explained above, is a promise from a bank to make a payment after verifying that somebody meets certain conditions. So, how is the risk exactly covered by a letter of credit? Well, the entire risk is based on the issuing bank. This is to avoid the risk that most exporters prefer to include their bank in the process and ask them to ensure the entire transaction. The way it works is that the buyer asks his bank to open the letter of credit. The buyer's bank verifies the solvency of its customers and the signatures in the application form. It also ensures that the instructions are clear and complete. The buyer's bank issues a letter of credit and sends it to the seller. The recipient sends the goods and prepares the documents as instructed by the letter of credit. The beneficiary sends the documents to the issuing bank, who verifies them. The issuing bank in return debits the buyer of the amount of the letter of credit and provides him the documents. The client can then take possession of the goods. In the end, the bank pays the seller. The last section in which I will focus in this video is the legal and technical issues surrounding the use of blockchain with regards to bill of lading. A blockchain is a shared accounting ledger that uses cryptography and a network of computers to track assets and secure the ledger from tampering. With blockchain, cryptology replaces third-party intermediaries as the keeper of trust, with all participants running complex algorithms to certify the integrity of the whole. There exists two types of blockchain, public and private blockchain. The public blockchains are open to all and use distributed ledger typically managed by a peer-to-peer network collectively adhering to a protocol for validating new blocks.
Wait, SpongeBob! We're not cavemen! We have technology!
So how is blockchain related with bills of lading at all? Well, bills of lading have been historically issued in a paper document. The aim of blockchain is to transform these bills of lading into so-called smart contract. A smart contract is a computer code made up of a network of blockchains, which in turn contains data. This computer code is supported by nodes that could execute an agreement once it determines the relevant terms have been satisfied. Now I turn to problems of bills of lading. The biggest concern is definitely lost, misplaced, destroyed, or even forged bill of lading. Most customers will dismiss this as a highly unlikely event, but anyone who has experienced it would do anything to avoid it again. It turns out that digitizing the bill of lading document is the perfect application for the blockchain. Why? Document traveling speeds go off the chart, overall costs are decreased by up to 90%, and native transparency and trackability ensure that lost or stolen documents are a thing of the past. There are, however, some functional issues to the use of blockchain with regards bill of lading. Firstly, lack of development and marketing funding. Secondly, lack of reputation. Thirdly, lack of trust in new technology suppliers. Poor computer literacy among users from the logistics industry. Lack of blockchain knowledge among users from logistics and trade industries. And lastly, the logistic industry, they are not known as a rapidly changing or developing environment. As regards the legal issues, electronic bills of lading have existed for a number of years with readily available platforms for their use, but these have not been so well received owing to uncertainty concerning the legal value of electronic bills of lading. This can be attributed to the lack of a legal infrastructure to support the use of the electronic bill of lading. Secondly, given that data processing could take place from any part of the world, there are questions on governing law and jurisdiction. Thirdly, a blockchain-based bill of lading in the form of smart contracts does not appear in the form of words but in computer codes, and many jurisdictions probably will not enforce bills of lading executed via platforms using smart contracts. In conclusion, the bill of lading is evidently the most important document in international shipping. However, this document form may be subject to change in the near future due to blockchain. Should you have any further questions, please consult other interns because I have no further knowledge to transmit to you. Thank you for your attention.